Good morning, grade 12. I hope you are doing very well. Today we are going to have a look at a standard employee contract. And this is very important because you can expect questions about employee contracts both in your exam in September and at the end of the year. All right, so this is a pretty standard contract, but I'm quickly going to go through it and just explain a few things to you to make sure that everybody understands what's going on. So you'll see this is on page 228 in your handbook. You can follow along in your handbook, or you can have a look at the slides with me as long as you read the contract. Okay, so your contract of employment also always starts with contract of employment between your employer. So let's say, for example, you are going to work for Mango Airlines, then that is where their name will be, and your full name. So let's use Dino as an example, and Dino Base, and then Dino's identity number will be here on this line. Then you have your employee details. This is also pretty standard: home address, postal address, home telephone number, cell phone number. This contract shall become of force and effect only upon the employee actually commencing employment on the following date. So then here they will put the date that you start work, and basically this just means that the contract will only be valid when the employee actually shows up for work. So that means that you cannot sign this contract and never go to work and still get paid. All right, pretty obvious, hey? This next part, contract of employment, just tells us which acts inform this contract, and that it's actually based upon our Basic Conditions of Employment Act and our Labor Relations Act. So that just means, guys, that it's still according to the law. We cannot just put anything in a contract like this. Then at number 2, we have the validity of the contract. So that means the cases whereupon this contract will be declared invalid, or things that are required to make it valid. So should it be revealed at any time after commencement of employment, so that's the start of employment, that the employee failed or neglected to inform the employer of any circumstance or information relating to, but not limited to, the employee's personal circumstances, state of health, criminal record or credit record, or addictions to drugs or alcohol substances which may have affected in any way the employer's decision to employ or not to employ the employee, then this contract shall immediately be rendered null and void. So in other words, it will no longer be valid and shall be of no force and effect. So guys, I want to look at an example here with you. Let's say this is a contract for a flight attendant, and the person who applied for the job, let's call her Sally. Sally suffers from epilepsy. So she gets epileptic fits. So let's say she went for the job interview. The employer was really impressed with her and they decided to hire her. But at no point during this process did Sally decide to declare that she has epilepsy. She goes on a flight. She has a fit mid-flight. She accidentally spills hot coffee all over one of the passengers, gives them second-degree burns, and the airline is sued. Then her contract can immediately be terminated because she did not declare that she had a health problem that might keep her from doing her work. The same goes for things such as a criminal record. Let's say that I have been convicted of theft, then obviously somebody is going to be reluctant to appoint me in a position where I might work with things that I can steal. So it is your job as the employee to declare things that might affect your ability to do your job. This contract of employment shall thus be construed as terminated, in other words, ended at the instance and fault of the employee. So it is your fault as the employee because you did not declare these things. And the employment shall be immediately terminated without payment or notice pay. Okay, this means that you are immediately out of a job, the contract is no longer valid, and they do not need to give you a month's notice or anything like that. And then obviously the employee needs to sign this and put a date there. Without a date, it will not be valid. Let's continue. Appointment. So this is now the job title. The employee is appointed to the position of, and here's where they will fill in something like air hostess, flight attendant, receptionist, whatever the job might be. Number 4, we have our job description, duties and responsibilities. In this specific contract, it is attached as an annex or an addendum, and you will also be required to sign that you accept that. So the job description outlines the main duties and key performance areas only as applicable to the requirements of the appointed post. So that, in other words, tells you what you will be doing while working at the company. Remuneration, that's your salary. So 5.1, we have the gross remuneration shall be, and then they also state whether it is monthly, weekly, or hourly. Gross remuneration means that this is before any deductions have been made. So you have not yet paid tax or UIF, unemployment fund. This is your gross salary. The following additional payments shall be made. So this is additional payments that will be made to the employee. These are all your allowances. So things like a cell phone allowance, a car allowance, or maybe an away from home allowance. This will be stated here. Remuneration shall be paid on the 27th day of each month. So a contract always states this as well because employees need to plan. So say, for example, I have a bank loan and I have to pay it every month, then I know it's safe to say, okay, the bank can make that deduction on the 30th because by the 27th, I will already have been paid. All remuneration is subject to statutory and other agreed deductions. So these again, guys, are my deductions as my pay-as-you-earn taxes that are paid to SARS on my behalf by the employer, or my UIF, or for example, if I agree that I will contribute to a pension fund, that will be deducted from my salary. All right. Let's have a look at number 6. Number 6 will stipulate the hours of work. So these are my normal working hours, and they will be filled in here. For example, Monday to Friday from 8 o'clock in the morning until 4 o'clock in the afternoon. And usually there's also stipulation for overtime. So the employee shall be remunerated for overtime worked at statutory overtime rates. So usually, guys, statutory overtime rates will be your hourly rate that you're usually paid if it is during the week. And for 6.3, this is now for work on Sundays, Saturdays, and public holidays. Usually in the industry, what is normal is to be paid 1.5 times your normal rate if you're working on public holidays or over weekends. Number 7 is our meal intervals. So this means the times that I am allowed to be away from work for lunch. So the employee is entitled to a daily meal interval of 60 minutes after 5 hours continuous work. So after I've been at work for 5 hours, I'm allowed to take lunch, but the meal interval shall be taken at a time approved by the employer. This is very logical because think of an office situation. If everybody takes their lunch hour at the same time, then the office is going to be empty at a certain time. And that won't work if any clients come in. So it will be according to an approved time by the employer. So say, for example, I will take my meal interval at 12 o'clock and you will take your meal hour at 1 o'clock. That way there's always someone in the office. So the meal interval is also unpaid time and it's the employee's own time. That means that the employer cannot ask me to do things during my lunch hour. That's my time when I get to take a bit of a break. All right, let's have a look at all our different types of leave. That's the next couple of sections in the contract. So first up at number 8, we have our annual leave. That is the leave that you get every year. And the employee, according to this contract, will have 18 working days. That means that it does not include weekends. It only includes days when I would have normally been expected to be at work. So you will also receive full pay during your annual leave cycle. That means when I'm on a holiday, my employer still pays me. The employee may not work for the employer or any other employer during a period of annual leave. So this means my boss cannot expect me to be at work when I'm actually on leave, but I'm also not allowed to go and work for someone else. Absence on unpaid leave for any reason shall not absolve the employee of responsibility to pay any monies due in terms of paragraph 6. All right. Okay, so this is also pretty standard. Sick leave. The employee is entitled to 30 days sick leave on full pay in every sick leave cycle, which is a period of 36 months, calculated from the date employment commences. So that means that I am allowed to be away from work because I am ill for 30 days every 36 months. So on any day that the employee is unable to attend work for any reason, the employee is obliged to notify the employer before 9 a.m. on the day in question of the reason for the absence and the expected date of return to work. Failure to so notify the employer will be regarded as an act of misconduct and disciplinary action will be taken. So this just means that if I have a stomach bug, for example, I need to phone my boss in the morning and tell him, look, I'm sorry, I can't come in today. I'm sick. I will be back tomorrow. That allows the employer to find a replacement for me for the day or to plan around that. But if I just stay away from work, even if I'm sick and I don't let them know, then that's actually a mistake on my side and they can take action against me. In the event of absence, I'm here at number 9.3, for more than 2 consecutive days, the employee is required to produce a medical certificate as proof of the incapacity. Such certificate may be issued only by a medical practitioner who is certified to diagnose and treat illnesses. This means that if I stay away from work for more than 2 days, I have to go and see a doctor and get a medical certificate from the doctor that says this is what's wrong with me and this is when I can go back to work. And number 9.4, note that it's the duty of the employee to hand a medical certificate to the employer. So it's your job, if you are sick, to go and get your medical certificate and hand it in to your boss. The employer shall not chase after the employee to obtain the medical certificate. That just means that your boss doesn't have to ask every day, hey, where's that medical certificate? You have to know that if you've been away from work, you have to bring your medical certificate, and it's not going to be your boss's job to say, oh, please, man, just please give me this medical certificate. I really need it. Okay, 9.5, should the employee fail to produce the required medical certificate on demand, then the period of absence shall be taken as unpaid leave. So in other words, if you don't give in your medical certificate, you won't be paid for that time. And remember, guys, this is if it's more than 2 days. Maternity leave, so that's when a person is pregnant and they're having a baby. Maternity leave is 4 months unpaid leave. That means you're allowed to stay away from work for 4 months, but you will not be paid for that period. However, you'd still have a job to go back to. The employee must notify the employer at the earliest possible moment of the pregnancy to enable arrangements to be made for a replacement employee during the period of maternity leave. That means that a woman cannot wait until the baby is almost due to tell her boss that she's pregnant. Okay, so at the earliest possible time, you should go and tell the person, look, I'm having a baby. This is the expected due date. Okay, so that they can also plan for this. The next point there, maternity leave must commence at least 4 weeks before the expected date of birth of the child, and the employee may not return to work for at least 6 weeks after the birth of the child. So this 4 weeks beforehand, guys, obviously sometimes babies are born a little bit earlier. It's just to protect everyone and to protect the mother and the place of work, because you don't want somebody unexpectedly to go into labor at work. 10.4, the absence on unpaid leave for any reason shall not absolve the employer of responsibility to pay any monies due in terms of paragraph 6. All right. I think this is actually a mistake. It refers to paragraph 5. Family responsibility leave. You've already talked about this a little bit. There's no family responsibility leave entitlement during the first 4 months of employment. So that means that you do not get family responsibility leave for the first 4 months that you work somewhere. Only after you've worked somewhere for 4 months, according to this specific contract, will you be entitled to family responsibility leave. After that, the entitlement is 3 days per annum. So that's 3 days per year on full pay in the event of the employee's child being born. So this is now reasons for which you can take family responsibility leave, or is sick, or upon the death of the employee's spouse or life partner, parent, grandparent, or adoptive parent, child or adoptive child, grandchild, or sibling. So if a family member passes away, in other words. Number 12 is quite important, use of company equipment for private purposes. So this is something that companies usually take very seriously. You're not allowed to use company equipment for your own private uses. Let's have a look at all these stipulations. The company provides the employee with computer and electronic communication equipment in accordance with the job requirements of the employee. Now, such equipment, including email facilities, is provided for business purposes only, and use for private purposes under any circumstances whatsoever is strictly forbidden. Any contravention of the rule in 12.1 above shall be regarded as serious misconduct and shall be addressed with disciplinary action, which may lead to the dismissal of the errant employee. So this means that if I take my email account and I email all my friends jokes and things the whole day, or I look for recipes online while I should be working, then my boss might actually have a disciplinary hearing, and if my conduct is serious enough, they can fire me. The employer constantly monitors the use of email and internet facility. That means that my boss actually looks at which websites I use and which emails I send. And this sorry about that, what a tongue twister. Monitoring includes the reading of all emails sent and received and the monitoring of websites visited on the internet by individual employees, as well as the monitoring of telephone calls made and received. So this means that if I'm on Facebook half the day, my boss will know about it. Any employee found to be surfing the internet for purposes other than strictly business, and in particular any employee found to be involved in or an accessory to the downloading or viewing of any websites that may be deemed to be undesirable or offensive in any way, will be subjected to disciplinary action and will be dismissed. Okay, so obviously, guys, something like visiting a pornographic website is a very serious offense. And your boss can say, look, this is completely wrong. I cannot have you working here anymore. And there will be a disciplinary hearing and you might get fired. Employees are expected to reimburse the company for the cost of any private telephone calls made. This means that if I'm at work and I use my work telephone to call my mother and to talk about nonsense, then the company can ask me to pay back that money. The employee agrees that the employer may make such deductions from the employee's salary, so they can take that off my salary, provided that the employee shall be notified 1 week in advance. So 1 week before I'm paid, they will tell me, look, you called your mother for 2 hours every day, so we are deducting this amount of money from your salary. All right. It is forbidden to download or load any software on any company equipment without the prior approval of management. This means that I cannot go and take programs from somewhere else and just go and put it on the computer. Obviously, this is to protect the computer. Yes, to protect the computer and to protect the company's equipment so that I do not upload viruses and things onto the computer. I know and understand the contents of paragraph 12 above. I understand the contravention of any section of paragraph 12 above may render me liable to dismissal. So again, the employee will sign this, and if I fail to comply with these stipulations, I can lose my job. All right, we're almost at the end here, guys. Termination of employment, that is when my employment is ended. The contract of employment may be terminated at the instance of either party to the contract by the one party to the contract providing to the other party to the contract written notice of its intention to terminate the contract. Wow, that's a mouthful. That means that if I want to leave my job, I have to put it in writing for my boss. If my boss wants to terminate my job, they have to put it in writing for me as well. Neither party to the contract may give to the other party to the contract written notice of less than 1 week. That means during my, if you read the rest of that, during my probation period, so let's say I'm appointed for 3 months on probation, I have to give at least 1 week notice. And if I'm appointed permanently after that, I have to give at least 1 month's notice. And the same goes for the employer as well. The normal retirement age of the company is 65 years. So when I reach the age of 65 years, I might be expected to retire. All employees will be retired upon reaching the age of 65 years, and upon retirement, all benefits as per paragraph 6 will cease with the exception of the agreed monthly pension payable. So guys, this is actually paragraph 5 where they talk about the remuneration. All right. Certificate of service. It is against company policy to provide work proficiency references to prospective employers on behalf of ex-employees, and the company will not provide such a reference even if requested by the ex-employee. The company will provide the employee with a certificate of service upon termination of employment containing the following details. So this is usually a certificate or a letter that just states when you worked at the company, what your duties were, etc. So in other words, they will not give a reference. They won't take calls from new employers wanting to ask them questions, but they will give a letter that said that you worked there. Okay, company policies and procedures. We're really nearing the end here. I know this is quite long. It is the responsibility of the employee to make himself or herself fully familiar with the content of all company policies and procedures, which may be obtained from, and here they will put in the name or the place where you can get this documentation. So this is things, guys, like our code of conduct or things like that. And it is your job as the employee to be familiar with these things. It's not your boss's job to sit you down and say, hey, look, okay, you have to dress this way and this way and this way. They can just say, look, here's the code of conduct, go and read through it. And then it's your job to actually do it. All company policies and procedures, rules and regulations, and the company disciplinary code form part of this employment contract as if fully written herein. The failure of the employee to make himself or herself fully familiar with the company policies and procedures shall not absolve or protect the employee from disciplinary action in the event of a breach of any company policy or procedure. Okay, let's have a look at an example. Let's say we're again talking about the flight attendant. The company policy might say that the flight attendant must wear a specific uniform. Now, let's say the flight attendant did not read the company policy and she shows up for work in jeans and a t-shirt. Then there can be disciplinary action against the employee, even though she doesn't know about this because she failed to read the procedures and the company policies. There can still be disciplinary actions against this person. So it's very important that all employees familiarize themselves with any company policies. All right, injuries on duty. That means if you are injured while you are working, employees shall be compensated for injuries sustained on duty only to the extent of the compensation allowed and paid by the Office of the Compensation Commissioner. The employer does not accept any liability whatsoever, nature for any injury sustained on duty. So this means that I cannot go and sue my boss because I got hurt. Reporting structure. All employees report direct to the managing director on her appointed deputy on all matters agreed to and signed at Johannesburg on this so for example the first day of July 2010. And then for the employer signs here, and then a witness will sign as well. For the employee will sign, and a witness as well. All right. And then just a note at the end of the contract. So guys, that's a pretty standard contract. Again, you can be asked in a test or an exam to answer questions about that. Contracts are an agreement. This means all parties have to sign the document to confirm that they agree with and consent to whatever is stated in the contract. So a contract will not be valid if everybody did not sign it. And often a contract will require a witness. So that's somebody who's not agreeing to the contract. They're just witnessing that this contract is being signed. And you'll see the rest of this little block explains that. And that they also explain that this is just to prevent someone from being pressurized or forced to sign a contract. A contract needs to be initialized by all parties on every page. That means that I will put my initials at the bottom of every page. Usually it's in the right-hand corner at the bottom. You just put your initials. So you don't sign it in full. On every page, you just initial to say that you've read it. It also needs to be dated and the place given where it was signed. All right. So that is it for today. I will talk to you guys again then tomorrow. Sorry, I know this is quite a long lesson. Good luck, and then we will talk again tomorrow. Bye, guys.